power of attorney for property is a legal document that lets you name someone to manage your finances if you can't. A viewer sent me a letter from her mother's bank. One line on it: "We require evidence of legal authority to accept instructions." Explained why the income had stopped. Her mother had an RRIF, a Registered Retirement Income Fund, the account that had been paying her monthly retirement income. It was frozen. Her mother had a power of attorney. It just wasn't the right kind. Most Canadian retirees have some version of this on their to-do list. The version most people sign, though, and when they sign it, is the gap that quietly fails them the moment it matters most. There are two kinds of this document. Only one of them works when incapacity actually arrives. The other one is what most people sign at the bank. Margaret had one. She signed it at the bank 8 years ago. It stopped working the exact moment it was supposed to start. By the end of this, you will know the difference between the kind that works and the kind that doesn't, why a joint account is not a substitute, and what the setup actually looks like. Let's break this into 4 moves. We start with what this document actually is, and what the word attorney means, because it is not what most people assume. Then the joint account, why it looks like a plan but only covers one piece of the picture. Third, the trigger, the legal definition of capacity, and why the timing of that determination matters more than most people know. And last, how to set this up so it actually works, the right document type, the right trigger mechanism, and the province-specific rules that decide whether it holds. Start with the first thing most people get wrong. The word attorney in a power of attorney has nothing to do with a lawyer. It means the person you appoint, your son, your daughter, your spouse, a trusted friend, who steps in to handle your finances when you can't. No law degree required. No bar exam. Now, there are 2 main versions of this document, and only one of them actually works in Margaret's situation. A general power of attorney is a valid legal instrument. You can use it to authorize someone to act on your behalf, sign documents, move money, manage property. But unless a power of attorney specifically states it continues through incapacity, the law terminates it the moment you lose legal capacity, meaning the legal ability to make binding financial decisions for yourself. Most documents signed at bank branches are silent on this, so they stop. The document extinguishes itself at the exact point you need it most. That is not a policy call by the bank. It is what the law says. A continuing power of attorney, in Ontario it is called a continuing power of attorney for property, is written specifically to survive incapacity. The word continuing means it keeps working after you lose the ability to act for yourself. That is the only version that actually solves the problem. Margaret's bank wasn't being difficult. Her document had a built-in expiry, and nobody told her when she signed it. When the compliance team reviewed it, they saw a general power of attorney with no continuing clause. They sent back the letter you saw at the start. They had no other option. Now, most people hear that and think, that's fine, I have a joint account with my son. That assumption is the second failure point, and it is just as expensive. The document gap is the first piece, but the joint account belief is the one that catches most families off guard. Kevin had access to the checking account. He had no access to anything else, and the checking account itself was not as available as he expected. The second move is the one that trips people up. A joint account looks like coverage. Kevin can access those funds, that much is true, but a joint account only covers the accounts that are jointly titled. The RRSP, the RRIF, the TFSA, Margaret's investment account, those are individually owned. They belong to Margaret alone, legally. Kevin has no authority to instruct the bank on any of them, regardless of the balance or his relationship to her. And here is the part most people don't know. When a bank receives a capacity event, many institutions will freeze or restrict a joint account pending formal confirmation of the account holder's status. This is standard risk management for the institution. The joint account that looked like a backup is not always accessible when you need it. There is also an estate consequence. A joint account passes to the surviving co-holder outside the estate. That is sometimes intentional, but it was never designed to manage finances during incapacity. The joint account covered one account. and only while both holders were legally capable. It was never a power of attorney. If you just realized you have been making this mistake, hit like so this reaches someone else before they pay another year of it. That is the joint account ceiling. Now the part most people never think to ask about, the exact moment the trigger fires. The legal definition of incapacity is more precise than most people expect, and the timing of the assessment is the part that can add weeks of paralysis. The third piece is what actually sets the timeline. Incapacity is a legal determination. It does not happen automatically because a doctor says someone is confused. Most provinces require a formal capacity assessment, a licensed professional, a documented process, a conclusion that meets a legal threshold specific to that province. That assessment takes time. The document can be structured in one of two ways, and which you choose determines how quickly someone can act on your behalf. A springing power of attorney activates only after the capacity assessment formally confirms incapacity. The attorney cannot act before that determination is made. In urgent situations, a medical event, a mortgage payment that cannot wait, bills that need to be paid today, that assessment window can run days or weeks. The authority springs into effect eventually. The problem is the gap between the event and the determination. An immediately effective power of attorney is in force from the day it is signed. The attorney can act whether you are capable or not. That places more trust in the person you name. The trade-off is real. Many estate planning professionals in common law provinces lean toward the immediately effective version because the assessment gap is the practical problem. But this is a decision that depends on who you are naming, what your family situation looks like, and what you are comfortable authorizing. That is the trade-off. An estate lawyer in your province is the right person to weigh it with you, not a call to make based on a YouTube video. That is the trigger trade-off. Now the part that actually fixes Margaret's situation. Setting this up correctly is 4 concrete steps, and one of them catches people off guard because it is different in Quebec. And the last move is how you set this up so it actually works. 4 things to get right. First, the document type. A continuing or enduring power of attorney for property. The version that survives incapacity. This is the non-negotiable foundation. A general power of attorney does not satisfy this. The word continuing or enduring has to be in it. Second, the province-specific form. Ontario calls it a continuing power of attorney for property. British Columbia and Alberta call it an enduring power of attorney. In Quebec, the document is called a protection mandate, and it works differently. A protection mandate requires a court approval step called homologation before the attorney can act. If you are in Quebec, that step is worth understanding before you need it, not after. Third, the trigger mechanism. We covered the trade-off in detail. The right choice depends on your specific situation, and an estate lawyer in your province is the right person to make that call. Fourth, witnessing. This document needs to be properly witnessed per your province's rules. In Ontario, 2 witnesses, who must be independent adults unrelated to you or your attorney, must sign it. A document witnessed incorrectly may not be accepted by a financial institution. It fails exactly when it is needed. This document covers your finances and property only. Personal care and health decisions need a separate document, and that is its own conversation. And there is one more step to complete while you are still capable. Pre-register your attorney with the CRA now before you ever need it. The whiteboard shows the 2 steps, and the description has the full procedure. Do not leave that for later. That is what the right kind means. A document that survives incapacity, signed with the right witnesses, structured for the right trigger, and filed with the institutions that hold your accounts. Margaret's family found out what the wrong version costs. The right version is 1 afternoon with an estate lawyer in your province. After the document is in place, there is one more practical question about where those accounts live. What made Margaret's situation worse was where her accounts were held. Her RRIF was at an institution with a branch visit requirement for any authorized representative change. Once a guardian was eventually appointed through the court process, the account access still took months to sort out. A continuing POA is only as useful as the institution's ability to act on it promptly. If the platform requires a branch visit for every administrative change, that visit is part of your estate plan, not an afterthought. Quick disclosure. The Wealthsimple link in the description is a referral link. You get $25 when you fund a new account with at least $100. What I earn scales up the more a new client deposits, so I have a direct interest in you using it. Check the description for current tiers and terms. Now, the honest scope on Wealthsimple and powers of attorney, because this matters. Wealthsimple's formal power of attorney program is built for their wealth management clients who work with an advisor on fully managed accounts. For most people watching this, that is not the setup you have. So do not sign up expecting to file a continuing power of attorney there this afternoon. What you can do at Wealthsimple, free, in a few minutes, is name a trusted contact person. That is someone the institution can reach out to if they see signs of financial exploitation or a possible capacity issue on your account. It is not legal authority. It does not replace a power of attorney. It is an early warning safety net that sits alongside the legal documents you set up with your estate lawyer. The point is not the platform. The point is that the attorney you name has the legal authority and knows how to access the accounts that matter. The power of attorney gives them the right. The account setup is how they exercise it. If that letter rings a bell, the next video to watch is Miss This RRSP rule and lose half your withdrawal to taxes. The continuing POA keeps your RRSP accessible when you cannot act on it yourself. That video covers the exit strategy, what happens to the money inside it, and why the timing is the decision most Canadians make too late. These videos are short on purpose. The cost of missing one is not. Subscribe so the next estate or legal planning piece reaches you on time. Here's the honest version. I can explain how this works, but the details that matter are yours, not mine. Bring it to someone who knows your file before you decide. Thanks for watching.